Hello, everybody.
Gentlemen in the Grand Traverse County Jail, may I have your name?
Anthony Bucko.
Good afternoon, Mr. Bucko. We are on the record in case number 25-5657 SM. You're appearing for arraignment purposes. This afternoon, you're appearing with Mr. Jarboe, the defense attorney available through the Indigent Defense Council here to assist you. And Mr. Jarboe, did you have opportunity to review allegations on the complaint, nature of the offense, and the possible maximum penalties with Mr. Bucko?
Yes, this is a misdemeanor complaint, as I recall. I want to bring it back up again. Yes, operating without insurance.
Thought this was the OWI.
Hold on, stop. From August 23rd. So at this point, he simply asked, he's aware of what the ticket's for, the charge, the maximum penalty under Michigan law, would waive further reading. He had entered a plea of not guilty and asked the matter be set for a pretrial. We did discuss options regarding counsel. At this point, he believes that he can handle this matter on his own due to the remedial action he's already taken. So he would ask that at this point, he's not waiving right to counsel on this file, but believes he can attend the pretrial on his own, see if he's successful.
We should also be seeing Mr. Bucko in case number 25-4817, which is also a operate without security. And it appears to me as though there's a bench warrant in that case. Nope, the bench warrant was recalled and will take no action. So Judge Van Alst has already seen Mr. Bucko in that case. My apologies.
Yeah.
So, is there any other reason, Mr. Jarboe, that Mr. Bucko is in jail regarding bond?
It is unclear to me. It is unclear to me. So I believe the answer is no, assuming that he's been arraigned on the other matter and bond has been set. He believes he's posted bond, but I don't have access to court records.
I have not been arraigned on the other one yet.
I want to make sure that we get this right. I don't show that you have any other pending cases other than the other driving unsuspended. In this court.
Okay.
Magistrate Rogers.
Ma'am.
It is apparent that the jail shows a felony probation violation detainer on Mr. Bucko.
Yes, probably. Yes.
Out of what county? Does it?
Grand Traverse.
Oh,
Grand
okay.
Traverse.
All right.
I'm up out of Antrim, ma'am. I think.
But the jail shows a hold
Okay.
by Damon
okay.
Herman.
Okay. Yes.
Okay, thank you. Thank you very much for that. So that
You're
makes
welcome.
a difference, Mr. Bucko, as far as providing you with, I'm going to place you on a $1,000 10% bond. So that, I mean, you can't get out of jail anyway if there's a hold. You'd be receiving credit for time that you're serving in this case. Not that, you know, you necessarily would need credit for time served and operate without security, but it might be beneficial.
Right, ma'am.
So in this case,
I just went to court for this the other day, the same thing, and they gave me court on but she gave me $100 10% bond because I'm not able to pay anything because of the parole hold. And then they set the date for the 21st of October. So now I'm here in front of you
we'll
guys.
schedule that same date, the 21st of October, for your pretrial conference. You're going to represent yourself in this case, right?
Yes, yes, ma'am. But
Okay,
for this, there's only one. I'm confused now because I just came to court on Thursday for the same thing. They gave me $100 10% because I'm not able to pay anything. That way I could get credit for the time served. Now you guys are upping it to $1,000. So how am I having two bonds?
It's
for
two
the same
separate
charge.
cases, Mr. Bucko.
But they were both the same day.
Well, you were issued two separate tickets, weren't you?
No, it's issued one. Is the other one from like a week ago from when I got locked up? Because it said August 23rd, and that was I already got arraigned on that on Thursday, and she gave me $100 10%. I got the paperwork in myself.
Again, I want to make sure that we do get this correct, so.
Yeah, because I'm confused too.
Okay. I'm easily confused. So
I got pulled
sometimes
over-
I need assistance.
August
No, I'm
23rd.
just, we're checking it out right now, okay? Hold on.
So I do show one for August 23rd, 11:03. Summit City Road. Well, near Summit City Road, sorry.
The 23rd, I was arrested. I was in
The
jail.
offense date in this one is, did you say August 23rd?
August 23rd for the 5657, which is this one.
And it's August 23rd in this one. Offense date August 23rd, 9:27 p.m.
Yeah, it's 11:03.
Two stops, same day, 9:27 p.m. and 11:03.
How I was arrested on the very first one, and then that was it. There should be one total. I was taken to jail.
Okay.
I was brought to Grand Traverse County and then went to Wexford the next day. This is where she just gave me the $100, 10%, just so I could, same thing, so I could accumulate
Right, and you
time.
don't want to, right, but you don't want to post any money, so don't post that one either.
I can't see the ticket. Okay, yeah, so it says here, Anthony Bucko was the driver and so occupant who stayed with this vehicle. For a reason for the same thing, they gave him a generous amount of time to produce a proof of insurance, but he did not.
Okay, what is the other one? Do you see the ticket? Very nice.
Oh,
The one for this case is not scanned in.
I do have two different. One was at 9 something,
9:20.
and this one was 11:03 p.m.
So Mr. Bucko, you were stopped
Yes, ma'am.
twice in that evening.
No, ma'am,
11:27 p.m., or excuse me,
It's the same spot.
whatever.
how does it stop twice at the same?
It's two separate violations. It's two separate cases for operating without security.
was
You're
pulled over
welcome to
once and
discuss
taken
this
to
with
jail.
your attorney.
You gotta get this shit.
And, you know, the bond amount doesn't matter. You're not going to post it anyway. I'll give you $100, 10% bond in this case. The same that Judge Van Alt had given you in the other case. But again, it wouldn't do you any good to post it because you're being held on the parole violation, right?
Yes, ma'am.
Okay,
Now,
so you,
is he gonna be my lawyer now,
Hold
or am I
on.
still at no lawyer? Sorry.
Mr. Jarbo indicated you were going to represent yourself at the pretrial conference. Are you representing yourself in the other case as well?
Yes, ma'am.
Okay, so we will schedule the pretrial conference for October 21st, 9:30 a.m. What is your correct mailing address?
496.
Mr. Jarbo, do you have any questions, sir?
No, it was confusing to me too, but it sounds like the court's found the answers.
So for right now, Mr. Bucko, you'll have two cases that you're going to discuss with the assistant prosecutor at the time of the pretrial conference. So just make sure that you're aware of that. If you are able to post those bonds, make sure that you provide the correct address to the 86th District Court where you'll be staying if it's any different than the East 8th Street, right? Because we have to mail you notices and information. We want to make sure that you get that information.
Yes, ma'am.
All right, so for right now then, sir, you are all set, I believe.
All right, thank you.
We will go on the record in the matters 21 CF 250, 25 CM 66, 25 TR 209, 210, and 340. State of Wisconsin versus Heather Olson. This date appears through special prosecutors, district attorney Aaron Marco by video conferencing. We have Daniel Chapman, defense counsel, in person with Ms. Olson. We're set today in these matters for status conferences. We do have a motion for entry of judgment in 21 CF 250. Mr. Marco, please update the court and let me know where we're going today.
Thank you. Attorney Chapman had asked me off the record if we were going to be ready to go forward with the hearing today. He stated essentially, and I would ask to defer to him, so I don't want to misspeak, but that there's no contesting any of the facts, but he did wish to argue whether or not the fact that there was possession of paraphernalia should be sufficient enough in order to vacate the judgment. I was just trying to pull up the deferred judgment of conviction agreement. If the court wants to hear argument today, I think it's pretty straightforward on, at least on my side. And we can do that today if it would please the court.
It would please the court.
We're prepared to do that, Judge.
All right, thank you then, Mr. Marco.
Well, as the court can find in the original motion that was filed by Holly Rockow, the allegation was that that Miss Peterson Olson had failed to comply with the condition that she would provide the AODA assessment as well, and then she committed the crime of possession of drug paraphernalia. The conditions, which actually violates multiple conditions of the deferred agreement, which are found on page 2. Number 1 states, I agree not to commit any criminal acts in this state or any other state. I understand that any chargeable criminal conduct, including non-criminal traffic, which survives probable cause, shall be grounds for termination of this agreement. Further, it states that on paragraph 9, I agree not to use or possess any illegal drugs, substances, or drug paraphernalia without a valid prescription. The fact that she was found in possession of drug paraphernalia that survived probable cause violates 2 of the conditions of which she specifically negotiated as conditions which are a basis for termination, and an agreement of 13 that says that she would get the AODA assessment done and turn in within 60 days, which
Can you
wasn't
just slow
done.
down just a little bit?
She's
Sorry, my court
violated
reporter
3 of the
is
4
trying to take down everything.
Does she need more time to catch up with me? I'm sorry.
Yes,
I can go whenever she's ready.
you're good.
She's violated 3 of the 14 terms. It's sufficient grounds for termination. The agreement should be terminated. Thank you.
All right, so just so I am clear, there were the grounds of the drug paraphernalia as well as the AODA assessment, but did she complete that AODA assessment? Do you have proof of that?
I believe she did later, Attorney
I'll
Chapman.
explain. Can I respond to that?
Yeah, I
Why
think
don't you
she
just
did
provide
it
an
through
argument
whole
and
life.
then you can do that?
I think she did complete an assessment through Whole Life Services. I don't see it. I'm looking for the date of completion. I have an AODA assessment, but it doesn't have a date on it that I can find readily. 4/24 of 24.
4/24 of 24. All right, thank you. Mr. Chapman?
She did complete the assessment. When the original motion was filed, she brought in a second copy and dropped it off at the DA's window. And then the district attorney's office filed a letter with the court saying, oh, it looks like she did turn it in. And the original motion was dropped. We're here about the arrest on March 15th, St. Patrick's Day of 2025 for possession of drug paraphernalia. And she's charged with OWI and her breath test was 0.075. I agree with the state that this is a by the letter violation of the agreement. It was a 2.5-year agreement. And aside from the assessment, which she says she had sent to them, and then when she was told to bring it in again, she did, but she did the assessment. This is her first violation, and it's possession of a pipe that was found in her car. So was it an old pipe? Was it a pipe that someone else had left there? It's probable cause. I completely understand that this is probable cause to have a pipe in her car. And she violated the absolute sobriety provisions also by being at a 0.075. Should the court revoke her? That's entirely up to the judge. And I'm not here to really convince you, except that it's a very serious felony. And in 2 years and slightly over a month or so, this was her only violation, was possession of a pipe in her car. I don't think that revocation in this case is really in the public's interest, and I would ask the courts to use its discretion not to revoke in this instance.
Are you still on probation?
Yes.
How long does that run?
2.5 years.
2.5 more
The
years?
agreement was set to coincide with the time of probation that was ordered. And that was in May of 2023, I believe.
How often do you see your probation agent?
Once a month, sometimes once every 2 weeks.
And are you regularly tested?
Typically, yeah.
What else do you do while you're on probation with your agent?
She has me going through a book. It's everything from like cognitive thinking and it's like treatment based in criminal thinking and so forth. So she gives me homework each time.
Any further argument from either side?
No, Judge.
Just the timing of it, it appears as though the assessment was done April 24th of 2024. The deferred conviction agreement was March of 2023 and said that the AODA assessment would be completed within 60 days. It took 13 months. Then another 11 months later, she possesses paraphernalia in violation of multiple terms of the agreement. And the particular assessment under its conditions also say on the very bottom that she is to follow all the agreement expectations and all the probation expectations and to be abstinent from substances. So she didn't follow the agreement, which wasn't timely, and she didn't follow it. Now, I certainly understand the request for use of discretion. This is a significant felony. These aren't overly egregious violations, but they do show a pattern of, I think when you look at the totality of it, of non-compliance. And the point of a deferred judgment of conviction agreement is that it's a person's last chance. It's the opportunity for them to work their way out of a very large hole that they had. And it's a gift of sorts. And it wasn't complied with. That's the bottom line. Thank you.
Thank you. Any response?
No, Your Honor.
I certainly agree that the deferred judgment of conviction is a party's kind of get out of a felony conviction type of card. And it's very serious because it could have serious ramifications. Here with this possession with intent to amphetamine greater than 10, less than 50, deferred judgment of conviction, if the court were to revoke the DJOC and enter judgment, Ms. Olson could face 15 years of initial incarceration with 10 years of extended supervision. And we're talking for a violation of an absolute sobriety and to not use or possess any drug paraphernalia or commit any other crime above probable cause. When we're looking at the facts alleged in the newest criminal complaint, the 25 CM66 case in which she was simply charged with possession of drug paraphernalia, it's not a very serious crime or allegation. She does have the corresponding tickets that are present with it with an operating greater than a 0.08 or an OWI first, but I don't have any lab information that's been presented to me to know if there was any illegal substances in her system, if her blood alcohol was greater than the alleged criminal complaint of 0.75, I believe, is what the PBT registered at. So I'm not even sure what would or could happen if this OWI actually goes to trial with the facts that are alleged in this criminal complaint. She was placed on probation, I believe, for 2.5 years back in 2023. So you shouldn't be on probation for much longer, I don't believe. Do you have an out date?
I think
Should be November, Judge.
This November? This isn't a very serious crime. Even an OWI 1 is serious. Again, I don't know where that's going to go. That has to go to a jury and or to a court trial. And that depends on a whole lot of factors. And you have a really sharp attorney right there who can argue the blood quantum, the alcohol blood in your system, which could very well mean it was not an OWI. What the court is willing to do is I am willing to allow the deferred judgment of conviction to continue, but I'm not allowing it to discharge in November. I want to see it extended for at least another year. Is that agreeable, Mr. Chapman?
It's definitely agreeable to us, Your Honor.
Mr. Marco? Is that something the state and the defense can get behind?
I'll defer to the discretion of the court.
Because this is very serious. Granted, Ms. Olson, I'm aware of her criminal history. I'm aware of her substance abuse issues. I'm also aware that that she does not have a conviction for a Class D felony, which again, with this type of felony can send her to prison essentially right at sentencing. So what the court is going to do is I'm going to give you one more chance. But again, what I am going to do is I am going to extend the deferred judgment of conviction for another year, which it would have ended November sometime of 2025. November 11th of 2025. So November 11th of 2026. I'm also going to state that along with the deferred judgment of conviction, that at least until your probation is discharged, that you have regular, at least every other week sessions and every other week drug testing, and that will be sent to your probation. And whether or not they extend your probation based upon whatever, however you've been doing in probation, that's up for the Department of Corrections to decide. But this is very serious, Ms. Wilson. You could go to prison for 15 years of initial incarceration and 10 years of extended supervision. Having a good time at a St. Patty's Day parade is not worth it. Not worth it at all. Or having a drink on an absolute sobriety is not worth it at all. So I'm going to, that's placed in the order. The court will make sure that I prepare an order that extends the deferred judgment of conviction. Anything further, we do need to set the other matters for another date and time.
There really hasn't been any discussion of settling the other cases, given the DJOC's status, but I'm confident me and Mr. Marco can work something out, Judge.
Are you able to, go ahead, Mr. Marco?
I was just gonna say, I would agree with Attorney Chapman, given the results of this hearing. I'm confident that Attorney Chapman and I can resolve the remaining matters in fairly short order.
Are you available November 5th at 2:45? I think that's,
Yes.
That's when I just set Mr. Tiarina, I think maybe.
No, you set him for the 15th, I think.
All right, so
No,
November
the
5th
14th, 14th.
at 2:45, we'll have a quick hearing to find out what's going on with this case. right, thank
11:05
you.
at 3:45, you said, Judge?
Yes.
Thank you.
2:45, sorry, 2:45. All right, we will see you then. Thank you.
Thank you, Judge.
We are adjourned.
You understand, that is the last chance. Like, that doesn't happen twice. So strict compliance, any technical oops is not going to fly again. Okay.
I have Mr. Paul coming in, I believe filling in for Mr. Cockerham.
This on Mr. Nitz.
Yes,
She'll give you a notice. Then we can talk outside.
and I don't yet have Washburn County.
They might expect me in the courtroom then. You're the
Oh.
out of county judge on that case, right?
Yes.
Be safe, be well, sleep sweet, and much love.